Hello everyone. So myself gaurangi kushwah, and today again I am back with my another video on exceptions to section 300 of IPC. So let's get into our video. Murder is a heinous offense which is punishable under the Indian Penal Code. Murder is defined in section 300 where culpable homicide amounts to murder. Culpable homicide, section 299, is genus and murder is its species. It is necessary that all the murder is a culpable homicide, but not necessary that all culpable homicide is a murder. The punishment for the murder is defined in section 302. There are certain exceptions provided in section 300 which states the case of culpable homicide which does not amount to murder, which is punishable under section 304 of Indian Penal Code. So now let's get into the exceptions to murder. So first exception here is sudden and grave provocation. When the person losing his self-control by the sudden and grave provocation causes the death of the person who gave the provocation or any other person due to a mistake or an accident, then he will be liable for the culpable not amounting to murder. The essential conditions are as the accused had not been provoked by the deceased, the provocation needs to be sudden, provocation needs to be grave, the accused had lost his self control or controlling power, the accused must have caused the death of the person who gave the provocation. The accused must have caused the death during the continuance of his deprivation of the power of self control. The accused should not have malified intention. Here we are also having a case law, a very famous case law, that is KM Nanavati versus State of Maharashtra 1962. This is a landmark case. In this, the court observed that gestures and words under certain situation can cause sudden and grave provocation to an accused so as to bring his action under this exception. For the purpose of determining the sudden and grave provocation, a test is established to find whether any other reasonable man having the same capacity and belonging to the same class or section of the society, if placed in the same situation as accused, would also be provoked as to lose his or her self control. The background of the previous act of victim is to taken into consideration in determining whether the subsequent act was sufficient to cause a sudden and grave provocation. The fatal blow on the person giving a sudden and grave provocation should be immediately when he was provoked, but not after the time which was sufficient for him to calm down or to cool down. Now let's get into the second exception, that is when the person exceeds his right of self-defense. When the person has a good faith while exercising his right to private defense of property, a person exceeds the power that is given to him and thus causing the death of the person against whom he is exercising his right without any knowledge or intention of doing anything more which is necessary for such purpose. If the accused exceeds his right of private defense intentionally, then he will be liable for murder. But if it is unintentionally, then he will be liable for culpable homicide not amounting to murder. For example, B attempts to flog A, not in such manner to cause grievous hurt to A. A draws out his pistol. B persists in his assault. A, believing that he had no option to prevent himself from being floored by at B, A is liable for culpable homicide not amounting to murder. In the case of Ranveer Singh and ORS versus State of Haryana on June 1, 2018, the court held that the burden of proving self-defense is on the accused. Such burden can be reduced by establishing a mere preponderance of probabilities, either by laying the basis for the plea in the cross-examination of the prosecution witness or by the adducing the defense evidence. In the case of Bhavar Singh and others versus State of Madhya Pradesh on 16 May 2008, the court held that the order to take the benefit of this exception, it is necessary to prove that the accused had the right of self-defense against the accused, and this right extends to causing the death of the person. If this is proved, then it would result in the application of Section 300, Exception 2. The court may reject the plea on the ground that the right to private defense exists, but more harm was caused than was necessary, or the right of private defense do not exceed causing the death of a person. Now, the third exception here is when the public servant exceeds his power. When any public servant or any person authorized by the public servant acts for the advancement of justice and exceeds their power, causing a death of person which in bona fide intention believes to be lawful and considered as necessary for the purpose of discharging his duty as a public servant, and without ill treatment towards the person whose death is caused. For example, A police constable went to arrest the person. The arrested person was trying to abscond. It the police officer shoots him. A is not liable for murder. In the case of Dukhi Singh versus State 1955 facts, the appellant to constable of Railway Protection Force while discharging his duty shoots a fireman unintentionally. He fired a shot to catch the thief who was trying to run. Judgment, the court held that the constable is entitled to the benefit of this section. Now, the fourth exception here is sudden fight. Sudden fight means when the fight was unexpected and premeditated, there was no intention of either of the parties to kill or cause the death of any person. It is not important fact that which party has first assaulted or who have offered a provocation. In this, the essential requirements are the case falls under this section only when the death is caused by, in the sudden fight, in the heat of passion without any pre-planned arising from a sudden quarrel, the offenders taking no unfair advantage, the offenders not acting in an unusual or cruel manner, the fight must be between the accused and the person who is killed. In the case of Radheshyam and another was the state of UP on 20th August 2018, facts the appellant got infuriated when he was told that his calf had come to the place of the deceased and started abusing the deceased. When he was being stopped from being abused, then he fired at the deceased. At the time of the fight, the accused had a weapon, but the deceased was unarmed. This indicated that the appellant had the intention to kill the deceased, and the judgment was the case was held liable for the murder. In the case of Dilip Kumar versus State of West Bengal, facts are the appellant had been objecting when the deceased used his file for the purpose of ingress and egress of the bullock cart. The complainant party, armed with deadly weapon, passed his bullock cart. There was a sudden fight, and as a result of a fight, the appellant and other two accused persons were injured. They killed the deceased. The judgment was the court, considering the circumstances of the case, held that the case will fall under this exception and the appellant will be liable under Section 204 of IPC. The fifth exception here is consent. When the person gives consent to cause her death, then it will be culpable homicide not amounting to murder. Essential requirements: the age of the person whose death is caused is above the age of 18 years. Consent is given to the deceased. The consent is given by the deceased. Consent needs to be free. It must be voluntary. Uh, for example, Anil, age 16, was abetted by A to commit suicide. Here, Anil was incapable to give his consent because he was immature and was below the age of 18 years. He is liable for murder. In the case of Vijay V versus the state of MP on 16 August 2018, the court held that the exception 5 to section 300 must have strict interpretation. No liberal interpretation is to be made, and in applying this exception, the act which is alleged to be authorized or consented by the victim must be scrutinized closely. So here the conclusion is there is always an exception to everything. This exception is given in order to protect the accused under certain circumstances, but the court must scrutinize the case properly when the accused pleads for any of the exception of section 300 in order to protect it from misuse of this section. So by this, I end my video here. Thank you so much. And I hope that you all have understood well. If you've understood it, then please hit the like button and subscribe to the channel. Thank you so much.